What in the Law podcast is back. Mike Harris here, and somehow I keep getting these respectable guests. Today we have Elizabeth McClintock, who defense attorney, mostly appellate lawyer,
Yep.
and city court judge.
Yes.
So I don't know how I pulled this off, but I got you. So why don't you introduce yourself to people? What is your law firm? What are you doing?
Okay. I'm Elizabeth McClintock. My law firm is Elizabeth McClintock. Well, McClintock Law Firm, LLC. Let's see what I do on a normal day. I do some trial work, but I've been trying to transition out of doing pretty much any trial work anymore. I'm trying to wrap up most of my cases that are at the trial level. But otherwise, I do appellate work for criminal defense clients who've been convicted. I also do appellate work for respondent parent counsel for the Office of Respondent Parent Counsel out of Denver.
Now, before we go too much, because I don't want to lose people,
Sure.
What does that mean?
So, in dependency and neglect cases, say the Department of Human Services alleges that you haven't taken care of your children in the way that they think is correct, they can go in and take your children away and put them in foster care. And so on the trial level, I've represented parents to get their children back in their homes. And then on the appellate level, I've represented parents where either they've had an adjudicatory trial and they've been found dependent and neglected, the children have, or at the end of a case where their parental rights have been terminated.
Okay. And I didn't want to interrupt the flow. What other stuff are you doing? And there is that kind of, I know there's one we got to talk about.
Mm-hmm. Oh, one more?
Yeah, of what you're practicing in.
Oh, yeah. So I do, appellate stuff. And then I also have as sort of a side, I don't know, I think the younger people call it a side hustle. I don't know.
Hustle.
Yeah, I'm a municipal court judge for the city of Woodland Park. I've been doing that for, 7 years now. It's sort of, we only have court up there every second and fourth Wednesday of the month. And so it's a nice break from my everyday practice. I get to go up there and handle traffic infraction cases, traffic misdemeanor cases, and ordinance violations. It's a nice community court. It's generally very slow paced. Some days it can be busier than others, but we have a lot of court trials, things like that happen, and it's a good way to serve my community, I think.
So maybe we'll talk about that a little more, because
Okay.
you
Sure.
can't ignore the judge thing, and
Right.
it's hard. So
Yeah.
how does that work in Colorado, where you can have a practice and also
be
a judge at the same
right.
time?
Yeah, you have to be mindful that there's no conflicts involved, and just try to, I don't practice in Teller County at all, so I don't come in contact with any cases that deal with the City of Woodland Park Police Department at all, because technically we all work for the city in a way. My judgeship is through the City of Woodland Park, so no one ever said I had to do this, but I've always done it, that I just don't take any cases in Teller County at all. The rules say that a municipal court judge should not take any municipal court level cases because there might be a conflict there, because you run into other judges that you run into at conferences and things like that. That was only recently clarified too. So I do not handle any municipal court level cases at all anywhere.
Okay.
So.
And I think maybe this is a good time to kind of talk about how the system works in Colorado. I mean, we keep tying municipal court. What is our system as far as we have these called county court judges, district court judges, municipal court judges? What is the difference of all these things?
So you have essentially three different levels of courts. You have at the district levels, which are state courts, they have county and district court. County court judges have to be residents of the county in which they sit, and they hear misdemeanor offenses, and generally more serious misdemeanor and traffic offenses like DUIs, all of those, most domestic violence cases, although some municipal courts hear domestic violence cases as well. And then district courts, of course, handle all felony cases and then civil matters. And then some county court judges also hear lower level civil court matters as well. But municipal court judges only hear cases that happen in their jurisdictions. So I'm limited just to the city limits of the city of Woodland Park. And we've also made decisions in regards to our ordinances that we will not hear any domestic violence type cases. If there's a serious assault where someone is seriously hurt, then we've asked the police department to always write those cases into county court because it's just not appropriate for municipal court. We try to avoid jail sentences quite a bit. And that's different in different municipalities too. Colorado Springs has a completely different type of system, as does Aurora, as does Denver Municipal Court. It's all different for different municipalities, but for my municipality in Woodland Park, we've made a conscious decision to try to make it just a community type court so that we can handle disputes between neighbors that rise to the level of assault, or simple assaults that happen maybe in a store, harassments, things like that. But that's, in a brief overview, that's how it works.
And I guess I think one thing important to remember is it's impossible to remember sometimes because it seems like it's different everywhere in the state.
Yes.
And
yes.
The rules in Woodland Park are going to be different than maybe the rules in Fountain or Denver or somewhere else.
Right. Yeah, we're all supposed to be guided by, in municipal court, the rules of municipal court, because Colorado does have its own separate rules, but the types of cases that can go into a certain court is different depending on the municipality.
And I guess it does seem like, at least not the big cities anyway, that it tends to be the more minor things that are usually not jail cases.
Yes.
Pretty much.
Yes, yeah. And I've always looked at our court as being a community court and more of an educational court. And we also we do have juvenile offenses that get written into municipal court as well. And in that way, we have a lot of resources in municipal court, and that's mostly due to the marijuana sales tax. A lot of that was tagged for municipal courts specifically. And so we've used that to develop wraparound programs for juveniles so that we can keep track of them and try to make sure that they never get to the level of ever having to be written into district court on a real delinquency matter.
And before we kind of leave the municipal court issue, one thing we were just talking about before we started the camera was penalties and the maximum penalties.
Right. Yes.
When you've never been in trouble and then you have something. What is that like?
Right. Yeah, because as part of your advisement at the very beginning of every case, you have to tell people when they come in, what's the maximum penalty that could be imposed for a case, and that generally disturbs a lot of people because they've come in, they have a ticket, they have written on the ticket, usually if it's an infraction, a certain number of points and then an amount that they could pay as a fine, and they've come to court to try to reduce generally the points. And then you tell them the maximum penalty that can be imposed under the model traffic code is $2,650. And then if you have a traffic misdemeanor offense, such as a careless driving offense, something like that, the maximum penalty could be that fine and or up to 1 year in jail. And most people have no idea about that, and that tends to really send them into a tailspin. So I try to make sure that people understand when they come into my court that I have to advise you of this. You need to know these are the maximum penalties. Now, whether or not they're ever going to be imposed on you is a whole nother matter, but you have to be advised about that. But try not to worry about that at this point in time. I just have to make sure you understand that's the maximum possible penalty, and that's it.
By the way, how often do people actually get jail for careless driving cases?
Well, in my court, no one has.
Oh, okay.
Because we do not usually have cases that involve any types of injuries or that are particularly aggravated. It's mostly just people like recently we had someone who was driving through town with a bunch of hay and that caused hay, literally agricultural hay. He was transporting a lot of hay and he got cited for careless driving and that, but that was not, it caused a minor accident. It was, so he got cited, but he came to court and it was resolved, and
So if there's a case that involved like a very massive injury or heaven forbid a death, would that go to the county court?
That would go to county court, and we'd ask for that just because typically in those types of situations, the amount of discovery is going to be greater, testing that needs to be done, things like that any defense attorney would want to have in the case. Maybe our city prosecutor, who's also a part-time prosecutor, she necessarily wouldn't have access to. Plus, if there was going to be a large amount of restitution, then the judicial district's restitution office and that should probably be helping to try to make sure that gets collected and things, if there's a guilty finding at all in the case. But I think it's just better. Plus, in municipal court, if you go to a jury trial, it can be to either 3 or 6 jurors, and you have to request it in a certain amount of time. There isn't an automatic default to jury trial, so some people's rights are better protected in county court as well. So again, another conscious decision, best to just put it into county court where things are a little bit set and people understand it maybe a little bit better, and they'll get appointed counsel even faster.
And by the way, the whole jury trial in city court, that pretty much varies from city to city pretty much.
Right. Well, I mean, any case that involves the possibility of a jail sentence, you should be entitled to a jury trial, at least as an adult. But you have to request it in writing within 21 days of the entry of your not guilty plea, to pay a $25 jury trial fee, and then you have to specify if you want 3 or 6 jurors to hear it. Whereas in county court, it's an automatic 6 jurors, and district court, it's an automatic 12 in order to be constitutionally sound.
And I guess the point, though, is people should make sure they check the specific city you may happen to have a case in, because it might be a different procedure in another town.
Right. It's supposed to be governed by the rules for municipal courts, but just always double check. That's a good point. Yes. And if you don't know, ask. That's another thing.
Sometimes I see a traffic case or a minor assault case, and in city limits, it'll end up in city court, and sometimes the exact same charge, exact same circumstances, same police department, it seems to go to county court. Is there why does that happen?
Yeah, it shouldn't happen. It should be, they should be consistent in what they're doing and where they're writing it into. I think it's officer discretion a lot of times too. But usually if the courts are clear with their police departments on how they want things done, they should be consistent on where it's written. So.
Okay. By the way, there seems to be some cultural differences in titles and judges. If someone were to see you out in town, not necessarily about a case, but they knew who you were, they knew what your job was.
Right.
Do people normally say hi, Judge, or do they?
Most people would just say hi, Elizabeth.
So it just seemed.
Yeah.
I just wondered why, because if you were to see a regular district court judge or county court judge, it seemed, it seems like it might be different. Is there?
Yeah,
is it a cultural thing, or why is that?
Maybe, I don't know. I never really advertised the fact that I was a judge in Woodland Park. For the longest time, a lot of people didn't know I was, and it's such a small court that unless you appear up there, then you wouldn't know. So it's not something that I really, thought it was important to tell everybody about. It's just, I like doing it. It's, like I've said, it's always been a nice break from my normal practice. And honestly, it's the one job that I do that makes me feel the most like a lawyer and the most pure practice of the law, because I try to make sure that people, I went into law to try to help people, and I do honestly sometimes feel like I help people when I'm a judge.
Let's talk appeals, because that's mostly what you're doing, right?
Yes.
Now, and when we say appeals, that actually, there's some legal words of appeals and then what average people think.
Right.
But basically, after a conviction has already happened is what we're normally talking about, right? Mm-hmm. So what kind of work do you do with that?
So it's mostly, the majority of my cases are still criminal appeals, although I do have quite a few respondent parent counsel appeals. And so what I do with those is from beginning to end. I do the notice of appeal, I do the request for transcripts. We make sure we get all the transcripts in from a case. I tend to over ask for transcripts. Some people like to pick and choose transcripts. I like to know everything that happened in a case, particularly if I had no information about it beforehand, so that I can just read it from beginning to end. And so that tends to then produce an awful lot of transcripts and paperwork in that. I have one appeal that I'm working on right now that has about over 2,000 pages of transcripts. And from there, so I'm very old school. Some people like to do everything on iPads. I only like to search for key phrases and stuff electronically when I'm having difficulty. And then there's another program that I'll use as well to find sites in particular. But when I'm working on a case, I like to honestly just read paper if I can, which drives, I know, some people crazy because that turns out to be a lot of paper. But for me, it's easier for me to read on paper.
I'm with you on that. There is something, I mean, going through the computer, you know, it works for some people, but it can be a lot easier to read, at least to me, when you have it just...
Right. I like it in front of me, and I like my old school method of using Post-its. I use a lot of Post-its in different colors, and I like to put them on things, and then I write notes beside them. And that's how I do an initial read of an appellate transcript. Is I just go through and I put Post-its down just as quickly as I possibly can without even really... I try not to judge even my own thought process on whether or not that's a good issue or not a good issue. I just say that's something that seems wrong, and I'll put a Post-it by it. And then during my second read through of transcripts, that's when I'll narrow things down to find what issues I really want to raise on an appeal.
And that's a good point as far as issues, because what I see when people come to talk to me about an appeal, what I hear more often than not is, I was convicted at trial, it was wrong, the witnesses lied.
Right.
So how does that work in an appeal?
Unfortunately, it doesn't work very well because really that's probably the least likely thing to be shown in a transcript, and you're limited by the transcripts that you have on a direct appeal. You can't go outside them, and so if the issue isn't right there in the transcript, it isn't clear, then you can't raise it on appeal. And whether or not somebody lied or not, that's probably something that perhaps the defendant knows because they know other information, but that contradictory information didn't come out at trial. And it's also not an actual, you could raise it as an insufficient evidence argument, but in my opinion, insufficiency of the evidence is always one of the weakest arguments you can raise on an appeal.
Yeah.
It's not the one that usually gets cases overturned. It's the one most clients want you to raise because they want you to argue, how could they possibly have done this to me? And I understand that. But really on an appeal, you're looking for all legal issues and all deficiencies in the legal proceedings. So the things that I like to concentrate on the most are jury instructions, any type of, obviously I mark every objection that's made by defense counsel in transcripts. I like to look at opening and closing arguments because generally there'll be objections made at either of those points of time, or people will go overboard in their closing arguments. And sometimes there's a good issue there to be made that made the case unfair.
And trying to think of how to say it, but generally you're looking for more, did the judge make a mistake, not did the jury make a mistake.
Right.
Would be, I mean, you can't really, well,
right. You don't know what the jury did. You can only know that the jury came to this conclusion. You don't know what they said back there in the jury room during their deliberations or anything. But yeah, and unfortunately it always comes down to, did the judge make a mistake? Because the judge, unfortunately, in the heat of the moment is the person that has to rule on every objection. And sometimes they get it right, sometimes they get it wrong. Sometimes it's just a point of view as well, or they didn't hear everything that really was there in the transcripts, and you can see it there. And that's just human nature. It's, unfortunately, you have to always say it's the judge's fault. It always gets blamed on the trial judge. I always feel bad about that because most trial judges are trying their hardest to get everything right all the time. And you just can't. It's human nature and I think to be especially a district court trial judge, you really have to have a pretty thick skin about things that come up on appeal, because you're the person has their name is always on it, but it's the law. You just have to keep that in mind. There's always a different interpretation of the law all the time.
And actually, one thing I was thinking of is in trial, things can come kind of fast and furious.
Yes.
And that for the judge, for the lawyer, sometimes I want to scream at the judges sometimes, because it's like, give me a break. I got all these things happening, so fast, and witnesses changing their story, and someone else is outside with something new, and it's hard to be that quick all the time and get every kind of thing perfect.
Yes.
So,
and that's the same thing with any kind of, you do post-conviction work at all, if it's a 35C. Same thing for trial attorneys, where people say, oh, they were ineffective in that. Well, most of the time it's not anything personal against the trial attorney. It's just, here's the fact of the matter is that you can't be perfect all the time. There's a lot of attorneys who are very excellent at what they do and get things right pretty much all the time. But
really?
Yeah, really.
All the time.
Pretty much. But at least under the law, yeah. But there's some times where there's a mistake made or something got missed, and that's where hindsight is 20/20. That's the clue to it, is that you have a better look at everything looking backwards on it.
And the other point I think that brings up is when a mistake happens, automatic new trial, right?
No. No.
So you're going to tell me about this word that they like to use on appeals, harmless. What does that mean, and what's kind of the reality people have to expect when they see a technical mistake?
Right.
How big does it have to be?
Yeah, it has to be pretty big. It undermined the fundamental fairness of a trial in order to get a new trial. And a lot of mistakes. I've raised lots of issues and then been shot down with still harmless, wouldn't have changed the outcome, and you're like, and it's frustrating because you're like, but I made this great argument, and isn't that the law? And then they go, but there was all this, we have all this other evidence, so whether or not that mistake was made, it was harmless. And so it's just it's disheartening sometimes, especially as an appellate attorney, but you learn to live with that too, unfortunately.
And I guess maybe a way to put it in the example, say you have 10 witnesses who say defendant's guilty, and you can prove beyond a shadow of a doubt that one of those witnesses, it was just something really wrong happened and that entire thing should be thrown out, but you still got 9 others. And that's kind of like,
so the court goes, well, even if they didn't consider this, that the other people were enough. So.
And sometimes that can be kind of a fine line, a little, I guess, arguable.
Yes, yeah, it can be, but I guess that's why they're the judges. And that's why you usually have another level of review that you can undertake as well.
And we don't necessarily need to go into all the specifics, but there's when you appeal, there's more than one potential chance, I guess I should say. And do you do appeals at all, like misdemeanors and felonies? And
yes.
And so there's some slightly different procedures as to who you're appealing to based on that.
Because from county court cases get appealed to the district court first, and so you have a district court judge sitting and issuing an opinion on that, and then you can file a petition for cert to the Colorado Supreme Court from there. Otherwise, for felony cases, it goes directly from the district court to the Court of Appeals, and the Court of Appeals has to take every direct appeal that is brought to them. So they are the most overworked appellate court in our state. But the Colorado Supreme Court doesn't have to take anything it doesn't want.
They basically choose what they want to hear and what they don't.
They pick and choose exactly what they want to hear, and if they think it's important enough to issue an opinion on them from them.
Now, you used some numbers in letter earlier. Maybe we should
Mhm.
explain what
Okay.
that is. You
Sure.
said 35C, which those of us who
sure.
are lawyers hear all the time, but maybe
Right.
some not. So, why don't we explain what that is, as far as, because that's a little different than the regular appeal.
Yes. Yeah. So a 35C is a post-conviction proceeding where a criminal defendant can raise issues that are outside the transcripts that you would have on a direct appeal. So you have to have your direct appeal first if you've gone to a trial, although you can raise a 35C if you've entered into a plea agreement as well, if there's new evidence or other information that the defendant feels was not brought out, or if their attorney was ineffective. So it's another avenue for criminal defendants in order to try to essentially attack, it's called a collateral attack, their conviction other than the direct appeal. And so they can have a hearing if they're granted a hearing and bring in information that normally isn't in the transcripts.
And people ask about that, I think, a lot, but how often does that tend to work out for people?
It's not a very successful route most of the time. You do hear about cases that get overturned that way, that have a lot of publicity around them. But generally you have to have an awful lot of information in order to win on a 35C, because the presumption is that, you know, everyone did their jobs the way they were supposed to. And, you know, when we talked about earlier about the heat of the moment and stuff, that the attorney performed to the best of their ability during that time frame, and that they met the competence standards.
Yeah. So we were talking about the appeals.
Mhm.
So these, you're doing serious cases, by the way, right? I mean,
Yes.
what type of level of people are, like, what are offenses are you tending to do mostly?
Mostly it is felony offenses and people that are already incarcerated in prison, and that murders and mostly sex offenses, things like that. Yes.
So this is what I have to ask you.
Okay.
So I mean, these are not just minor things. These are people dying, child sex assaults, horrible,
Yes.
horrible things.
Yes.
And when you're doing appeals, they've already been convicted.
Yes.
So I got to ask the question.
Mm-hmm.
You may have heard. How do you defend these people?
I very, very easily I defend them, and that's because I believe in the law. So, and I really do. People assume that, you know, facts and what people have been accused of doing and that a jury has found them guilty of. First of all, I don't necessarily always believe that that's correct, that it was done correctly. And then two, if someone was not convicted correctly, if there were constitutional errors in their trial, then that needs to be brought to light. I people always talk about, you know, and I'm not like a true believer that everyone is innocent or anything like that, but I do believe in our rule of law, and I believe in that pretty strongly. I believe in our Constitution. I believe in everyone has to face their consequences in that, but I believe in fundamental fairness as well in our system. And so I really do not have a problem defending people who've been accused of pretty terrible things, and I have my entire career as a defense attorney anyway, defended people who've been accused of pretty bad things. And I've gotten that question a lot, and I'm like, I just believe in making sure that everybody, you know, gets a fair trial. And one of the biggest parts of that is making sure that everyone has competent representation. I think that's probably the biggest part of it, because if the defense attorney isn't doing their job, then the whole system falls apart, and it's just vitally important. And I've always believed that.
Do you think innocent people do get convicted of these serious things sometimes?
Yes, I do.
Why do you say that?
Because there have been people that I've been convinced have not committed the crimes that they've been convicted of. And they are still in prison. And I think that, you know, the reversal with DNA on some cases has proven that that happens. And oftentimes, you know, people hear the types of charges and they make up their minds, and they can't help but make up their minds as jurors sometimes. But I also don't believe that everyone in prison is innocent either. So, I mean, people do get rightfully convicted of crimes that they've committed, and that's also reality too. So,
right.
Yeah.
Does it, just as a person sometimes, how does that affect you sometimes I mean, you're reading horrific things. This is not just bland
Right.
reading sometimes. I mean, sometimes it's pretty bland, I assume, but
Right.
sometimes it's pretty horrific, emotional stuff you're reading.
Yes.
How is it dealing with that?
It's difficult sometimes. You have to take a break from things a lot of times. I don't think people realize that, how much just reading or looking at exhibits and things like that can have an emotional toll on you. I think it's called secondary trauma or something like that. But I try to keep a pretty diverse bunch of interests outside of the law too.
Yeah.
I do a lot of, believe it or not, home decorating helps me a lot. I paint walls a lot. I paint furniture. I do things where I can concentrate on other things and not think about it a lot.
And there may be some people thinking about being a lawyer
Right.
or thinking about what they want to do in the law, maybe checking this out. What would you say to someone who's thinking about this type of work? About, I mean, not just doing, misdemeanors or DUI work,
Right.
but these, frankly, horrific felony
Right.
charges. What do you need to know before you start doing that kind of stuff?
Well, so before you go into it, you probably should just know yourself pretty well. You should know whether or not you have an open mind about things. And that changes over time too. I mean, at the start of my career, I was a prosecutor, and I had a pretty diverse upbringing, but it was still not, I didn't see everything that I saw once I was a prosecutor. And I certainly didn't see everything I saw once I was a defense attorney. And you really have to be able to see the gray that's out there in the world. Everything is not black and white. There are degrees of responsibility and criminality and things like that, and you have to be understanding of that. But anyone going into law, I think it's still a great profession to go into. It's, it needs people who have an understanding of it, who have a desire to really uphold the Constitution. I know that sounds strange, but some people go into it thinking, I'm just going to make a ton of money and do that. That does not come automatically, making tons of money. And you have to work very hard in order to make money. And it can be really difficult some days. And, I have bad days too, where, if I lose a case of, I feel bad about it. I feel bad about it for weeks. And you have to be prepared and know yourself pretty well.
Yeah.
But it is still a great profession. I always encourage women to go into it too, because I think it's a great profession when you have children. I think you can go in and out of working in it and working harder when you have the time to do that, or stepping back a little bit when your children are young. That's kind of how I did things when my kids were born, and I was able to, juggle having 2 kids and working full time still and having a career, and I didn't feel like I missed out on a lot.
Well, this sounds like a good point to talk about you a little bit more.
Okay.
And how did you go from get into law, become a lawyer, and then become the appellate lawyer? We still got to talk about your trial practice a little bit, but this sounds like a good segue to talk about you.
Okay.
How did you get into this?
So no one else in my family except for now myself and my brother were attorneys. Everybody else is engineers, and my brother's a minister and that. But I honestly was going to go to college and become an actress. I had a scholarship to Pepperdine to study acting and that. And then the more I thought about it, the more I was like, I don't know that I want to be on a diet my entire life. I don't know that I want to, have that much insecurity. And honestly, I saw an interview with Katharine Hepburn one time where she said that if she had to do it all over again, she would have been a trial attorney. And so I was like, well, maybe that's a good idea, you know.
It seems like there's more lawyers who would rather be an actor, but
I know,
maybe
right?
they haven't tried both and don't know.
Yeah, I wouldn't know how to do it now, but so I was like, oh, that might be a good idea for me. Plus, all the acting classes I took as an undergrad, I never really seemed to fit in with everybody else in those classes, but I did fit in pretty well with all the poli-sci people, so that's the route I went. And so,
well, what was your background as far as law school profession and how, you know, the different jobs you had up until now?
I poli-sci pre-law was my major. That's what it ended up being for undergrad. I went to University of Wyoming, and I'm from Wyoming originally. And then while I was in undergrad, I worked for a year in Washington, D.C., and that was pretty informative for me because that was when I worked at the National Endowment for the Humanities for Lynn Cheney. And then it was during the first Gulf War in '91. That's how old I am. You can tell. And so it was just informative to see how government worked and things like that. And then I was like, went back. I was supposed to go to school in Chicago for law school, and then decided it was way too cold, colder than Wyoming. So I stayed in Wyoming and went to law school there. And then I got married and then moved down here to Colorado Springs.
I'm tempted to jump into the political issue since you just mentioned
Yeah,
JD, who has I guess she's coming up for election, but we'll stick to the law.
This was her mother.
Oh, this is the okay.
Yes.
I can't keep track of.
Yeah, no, her Dick Cheney's wife.
Oh, okay.
She was the director of the National Endowment for the Humanities at the time he was Secretary of Defense. And so there were a whole bunch of Wyoming people in Washington, D.C. at that time. I mean, a lot of Wyoming people. It was very strange.
Half the state was probably over
there, right? It felt like it, yeah, really. And so, but it was a great learning environment for me. And pretty much everybody in Wyoming's a Republican. You can't get away from that.
Yeah.
But I don't know. Again, there you go. So as you grow older, your views change. I was always told you get more conservative as you get older. I don't think that's been the case with me. So
for me, it's the complete opposite.
See,
so we're all different, I guess.
Yeah.
So, and you said you're kind of closing out your trial practice a little bit, but what kind of? But you're also doing some trial work, or what are you doing there?
Yeah, I'm finishing up cases that I've had or cases that I've taken on that should be finished up fairly quickly, I think. But mostly, we just finished up a 2-week sex offense trial. And then I have a few more cases set. A couple of them are just misdemeanors, not just misdemeanors. They're, important to the clients.
Right.
But, and then otherwise I have one fairly important adjudicatory trial in a dependency and neglect case that I have coming up. So.
Okay.
Yeah.
How much of your work is like private versus are you court-appointed work, or is it like a combination?
So I would say about 75%, well, almost all of my criminal defense work is private. And then on the dependency and neglect and or PC side, 100% of that is court appointed through that agency. I'd like to take some ADC appeals, but I just haven't been able to, I guess, hook up with the right person again since I started my own practice to get that set up. But
and we're saying, for those who don't know, ADC, we're talking about the where the public defender is a conflict and the government appoints you.
Yeah, the alternate defense counsel. Yep.
I see. So how do people find you?
They can find me on the internet. Usually, most of my clients are referred to me. It's a referral of people who've had cases that, or other attorneys who had cases go to trial, and they know that the client wants to have a direct appeal. But otherwise, mostly on the internet, people look and search for appeal and things like that, and that's how they find me.
So what's the website?
Oh, what is the website? www.McClintocklegal.com.
We'll make sure we have it written down there for people to easily find.
It's pretty sad. I'm like, what is my website?
You have well, as I do. I assume you have help out there with the website stuff.
Yes. Yeah, all of that, because I was, I guess, the generation before that. I just don't know that as well. So. Well,
it's a lot of stuff to keep up with.
It is.
And actually, maybe I'll wrap up with this point, because as a lawyer, we think about the pure law stuff, the court, the transcripts, writing.
Yeah.
But there's a whole nother aspect. So when you're in business, when you're not with the government, at least, well,
the business
what's that
side.
like? Yeah, what's that like?
Yeah, it's always something, keeping track of, well, taxes number one. That's always, when I went to practice on my own, was remember your taxes. That's the most important thing. Never get sideways with the IRS or the state Department of Revenue. And, you just want to keep track of, it's always good to have somebody helping you who keeps you on track with things like, you need to find a decent accountant. You need to find somebody who can help you get everything set up the way it should be, and make sure that you file your quarterly reports for, if you have employment. If you have employees, you file your unemployment reports and that quarterly, and and your yearly report with the Secretary of State. Don't want to forget that. You're tagged with a fine, not necessarily a fine, but they up the cost of filing it a lot.
Yeah.
And there's always something. You always have to keep on top of all of the business aspects of it, and making sure that I'm not as good at figuring out my bottom line stuff. So luckily,
I know that feeling.
I'm married to an MBA, and he helps me with that stuff now. But I can usually keep track of deadlines and things like that in my head and stuff like that. But the other stuff, I generally need help. I always recommend people get help.
Well, thank you so much. Is there anything we should have asked? What other questions do you got, Lauren? What else should we be asking?
You answered my question.
I answered all your questions. Is there something else we should talk about? New and exciting, or
best part about being in private practice is being able to. Well, I don't necessarily get to call my own shots or my own schedule necessarily. Judges still control that a lot, but I do get to bring my dogs to work, so that's nice.
That is. So, well, thank you so much for coming on, and this was a really good talk, because there's so many different aspects and areas and, frankly, perspectives. So hopefully we will educate the world about some different things here.
Good.
So thank you so much for coming on, and see you guys next time. Remember to get me those subscriptions, likes, comments, and all those things, and see you next time on What in the Law podcast.